Ghana nia sebio ono so ye professor we hu Chief Justice nyoma bi a waya sebio entwa ye Ghana mra no e ma ye ho kwan se ye hu se sebio eye nipa bi a oye dwuma ma aban anase Akufo-Addo ato ne nsafre no ana eyi no se ondi dwuma bi no ye constitution no e ma ye ho kwan se we ye citizen na se ohun se nipa no we bu mra so ana we di dwuma bi a enkoyi a obetuma atwera koma president no na president na ahwehwem president hwehwem na so ohun se nipa no edifo a president no ho kwan se obema sa akrata na akọ eye council of the state for no no mo so dey ama another committee a ye be yi nipa ahodo bi mo matena so apensen mu se nipa no sebio the petitioner no ana nipa no dey asem koto president nim no o wongina so a o se president making sure say sa nipa no so we bu emra so nko ade a se emra na ye kenkan no we bu so a o se sa nipa no ye pam no intenda nwumbre petitioner koto Akufo-Addo na so efa chief justice ho no me be kenkan ne brofum na madwudwam ni nyina ewo asante kasem ana twi kasem ana kase bi a wa wote ase a me hu se twi kasa na mechanic kese no se ne be ye nyina ebeti ase se ne be ya ochena no nipa bi entumi enkotena radio so TV so enko kansem bi nto John Mahama so enko kansem bi nto NDC so asem we esiwe Akufo-Addo preso me no ka say Nana Danko Akufo-Addo one na ye president in the next 24 hours obetumi take a decision so sansem we nyina hia into we will take the time we have time a 19-page petition. We will take our time to read every single page of the petition. Send your beya Ghana for Ebehuno Kreno. We didn't the cabinet called Bedu Taylor. Show way your friend with all respect extended version. You're the free United States of America. And yeah, they bro, me team no, they are on standby to make sure say no Kreno na one saka. Intuition more YouTuber. Thank you very much for tuning in. And then my father just texted me. Thank you very much, Kapo, my son. I really appreciate you. My father just texted me. And easy. My father just texted me. He's watching me. Jack. My father texted me. My father texted me already. So it's very important. Team, should I do a little bit of social media slot, or we should go straight and take care of business? We have lots and lots of things to do today. Read. We have lots and lots of readings to do. Be assured, says so many people are ready to listen to petition. No, the womb. No, Matthias here. That's the new journalism we are introducing to Ghana now. So, team, I think we should just go straight and read what is in the petition. After that, it's a time we can do a little bit of social media segment and then end today's show. I'll be doing a lot of reading. My mentor said, to me, I can position this laptop somewhere around here, because the reading will be a lot. My mentor, what I can do. I need to move a few things around on this platform. And you bring now, Yentumima Ubia ente the air conase. Yepese Ubia the air. So yeah, let me first start with this theme. All right. My team, I'm green light and say I can go ahead and do the petition. The ready and no be anti-ase. Into mama shemi nyina from my mena from auntie ne frɛ o papa ne kan that na se Kevin so obekin kan petition bi aba menkotie radio bi mo bi ndada o. Omo be kan caption natural. Omo wi a no kure na wo mu no omo kan kyerɛ. Kevin Taylor say obenya botre aken kan petition no de wo mu nyina ma Ghana fo ate ase. Be kan ne brofo kakra na medwudwam. Be kan ne brofo kakra na medwudwam. Ene de brofo. Aboatwe. Ene de brofo, ene de bedwe. Inti brofo no ye kan na ebuma mamma mbumfu e brofo aye nyina ekusia aye arish kontomre. Ba ye kan enya ne fine so adom de nya botre na yeso ye kɔ edim. Inti we ebe brofo gwa, but me kan brofo na ma kyerɛ mu otwi. Me kan brofo na ma kyerɛ mu akankasem. Se ne ba ye ma amenom ye papa no obi abeti ase na obi mfa ase bi nkoto John Mahama so. Very very important. Inti ansa ne ye be kono obi anum so kakra aboatwe. Ba he madam for sofo bi, sofo pa, sofo kese pa Ghana. Wa text me aboatwe original sofo. Sofo. Madam for sofo penyini omu nyina mu ni na se katindra na oka ho. Za sofo. Mi body dia mu nyina mahu. Na se katindra na oka ho. Wa taxi for si aboatwe original. Sofo Ghana sofo. Sofo me mamo idea kiti obehu sofo kro. Sofo no orhe bi shoro no ka jam se. Sofo no. Sofo na mi body this is yaro. National Cathedral, Okaon. Abuache, and you start here. Ono so for that text me. Sharp, Abuache, original. So for that text me, I was off way. The Ghana was that the original also? Also for way. Me see, Ghana so for more. We are stubborn movie. All right, mommy and your guy, you matter now. You quit him now. We dear so for which ya. So for no can I say Cathedral or no, just no. Otia Abuache, I text me Abuache, original. So for. All right, what there? me can be my son body di me nyempo ma me ko benim. All right. Now sofu hey me conquer me sofu we pa munim no me say unim me ehun me won nam fom pedifo bebre o Ghana from court to ahemfo to there sofu we obi anim no Ghana me na me ka kire obi anim no are you famous National Cathedral o ka ho ono text me say abuache original there me yade say or the original so there's sofu you. All right, now yes, Paul is who say me say Paul any 24th no wo say mu no tips wo politics ekuno Paul bo ma me fangi na dey be kan bro funtima me no bro tea kakra we tea no ye e dey na abobo information aboko mo ma me no we no kakra na me di ginema sofo no we tea no am say kebitila oba na the bottle bia ba we na wom we tea we and oboa original abuache. All right, now let's take our business. Now, sorry, and then you the breaking news in the say the Chief Justice, President Akufo-Addo petitioned to remove Chief Justice from office. Obi a petition another than Akufo-Addo, Professor Kwaku Asare, Ghanaian professor, or the petitioner command another than Akufo-Addo. Now petition no, or see ye Chief Justice in free. If you say Chief Justice wabo brabia sabra no etia Ghana sebio yemra ebo sebio oman ho bra eye ye constitution no ene emra ebo eye judiciary eye sebio eye omo a omubu ensem a Chief Justice eda no ewo eye de Ghana no na ensem na eye abranti a Akufo Addo say Ghana man ho kwan ena Ghana constitution man ho kwan say se yetu yensa anase yeyi obi president tu obi se ondi dwumabi ema Ghana na nipa no wa misconduct no anase dwumade no wedi no wan di no kwan also disu no obumra so a Ghana for as citizens no your right to see abekacha president say nipa we die sebio nyoma we ni na wa ya e kire say edwuma odoma no we bu Ghana mra so ebu yenim tia ema mra na we bu sininti ehia se nipa no betena e ne office samukaya time another Danko Akufo-Addo eba office in 2017 anche ena mrantie bi Echro krata koma Akufo-Addo say Madam Charlotte say oye the EC boss no sebio Ghana emra ma Ghana for to me say omonchro krata emra president no mo fama tu nanim say sebio nipa ye friend Madam Charlotte say no sebio time na oye EC boss no nyoma bi wo ho a oye ya amfa kwan mu na etiamra entina na Danko Akufo-Addo enhwe sa nyoma no ngina so na onfa sa ensem no enkyere Council of State no the check Council of State we are ombie committee na committee no agitum say Charlotte say and conducting who ya or say twena so sa emra no ena na Danko Akufo-Addo edi so mampanyini a odi yi Charlotte say free electoral commission ene obi atchro petition de akwa na Danko Akufo-Addo odan ho the same president na krata na otchro no otchro de epo ana points ana engina so enyina hye mu kire Akufo-Addo say wenti ena ende me ka kire wo say Madam Torkonoo no pamono as the Chief Justice of Ghana. Now mama yanko kan krata no de ewom said the baya ochina kwase bi embetena wuntumi TV Jimmy Phobia no kanka bi embetena Peace FM sebio political goat bi embetena bebi embetum futuro ngumani we dwumade a yedi de ayeden ama Ghana for ehu nokure a yede kekere man. Now krata no mebie so ha if we say edos ye 19 pages. So I will take my time and read the 19 pages to Ghana for. Now krata no offer krata fan a day nim the first page. Hey and there. Obianya ready na yebedwum 19 pages ye pon ane apon. Now ohwe krata no so a omachro 17 December 2024. In fact, this is a public document. Okwa abontene a ewo ho obia obetumi akan. 17 December 2024. Now Mr. President office no omo receive sakrata we Ghana time 4:33 p.m. Reception no nipa na oje krata no the number e da so 0244194142 ono ena sebio or reception ho krata no kosi ni so di Joseph Kobena Wuba ono ena je krata no sign ye ka say yaje ye da koma president inti sia na me no ka say sa petition no e da na Danko Akufo the table so na krata na nkasa o kan a de wo mu nie brofo nie mewi ana medwudwam nipa sebio o petition na Nana Akufo-Addo ana MPP aban we no nipa ye frɛ no amefa ne picture nto so ye frɛ no Mr. Anasa Professor Stephen Kwaku Asare onie oye Ghanani mapa oye professor oye Ghanani osa kira de America ote Ghana sati America watro krata we oye Ghanani mbra ema no ho kwan se ono so de nano asem ene ngina so a owo ede betu Akufo-Addo nim se ontu ho anamo nti abrantie ana papa yi a ye friend Professor Stephen Kwaku Asare ono ene kiro krata we ede koma Nana Akufo-Addo o se yendi ho dwuma efiri se Chief Justice Madam Torkonoo abobra bia bra no eni se otena office se Chief Justice of the Republic of Ghana. Now mama menko krata dim na medwum ahanko na obehu saade we uhu bi obebi abiem omo amaka nyina omo read caption a kire no motwa wotro eni ntina mse nya abotre me na wo kan brofo na madwudwam. All right team. And somebody is drawing my attention to something. The petition was written on the 17th, but the person who received the petition received it on the 16th. So the petition was received before it was written. But we will deal with that matter. Let's look at what is in the petition. The petition was written on the 17th of December 2024. But Nipana or receive petition or Jubilee House no date is 16th of December 2024. So it means somebody is being diabolic in the Jubilee House. From what we are seeing on the petition, that means the petition was received before it was written. But we will get to that part. We will break it down. Thank you very much, team. Now, petition again, or say 17 December 2024. His Excellency, the President of the Republic of Ghana, Jubilee House, Accra. Dear Mr. President, petition for the removal of the Honorable Chief Justice of the Republic of Ghana, Her Ladyship Gertrude Torkonoo, CJ, pursuant to the provisions of Article 146 of the 1992 Constitution of the Republic of Ghana. Assembly no anase caption no anani tipo ne kire say or say sakrata or trabre krata ogina Ghana the Constitution so de akire Nana Akufo-Addo Ghana nyina say mbra no hye ne keten say sebio the Constitution aka no sa petition anase asem obetu anim no ogina Ghana Constitution so na ode kire sakrata na bre Akufo-Addo enti enye say ne pe wahwe Constitution no wahwe mbra no na ogina so de akire krata no de ama de Ghana say Nana Akufo-Addo ontu ho anamon. Sorry guys, I beg you, don't distract me. I'm not talking to my team. People calling my phone. Introduction petition page 1 or say I, Professor Stephen Kwaku Asare, a citizen of the Republic of Ghana, respectfully submit this petition to Your Excellency, the President of the Republic of Ghana, seeking the removal of Her Ladyship Gertrude Torkonoo, the Chief Justice of the Republic of Ghana, on grounds of or say or no I friend Stephen Kwaku Asare oye Ghana ni mapano or trakrata we e de bre Nana Akufo-Addo say Chief Justice Chief Justice Madam Torkonoo no was say opamono na ingina so a ogina sunie or say 1 stated misbehavior and incompetence or say nimba nyoma mienu na ogina so e de aka kire Nana Akufo-Addo say was say Chief Justice no ya pamono opamono enime ya na nyoma mienu no say Chief Justice no sebio eba den eba bibia ye frɛ no den ni amoho nsɛm ni misbehavior omumra omunipa sebio de opɛ ɛna ye ka sɛ incompetence udi dwuma ma na ontumi ndi dwuma no sebio nyansa ye didi dwuma ɛma yehu sɛ wedie ye de nyansa pɔ ɛna di dwuma ɛma dwuma egina ne naso no ɔsɛ ye ka bibi te sɛ incompetence sebio oni saa nyansa kadeɛ na yetumi di dwuma ɛma dwuma esipi incompetence and also they stated misbehavior or say or wahomaso ene ne su ene ne ban bia sebio odi bu mraso nti nyoma mienu na ogina so e de aka che na Nana Akufo-Addo say on pam Chief Justice no na answer na osalo dinka ka say Constitution ne ma ne ho kwan say the ayen na no te say Charlotte say time no ye betumi so ayen ne ya into osteti e article a ogina so e de atro e krata we e de ama Nana Addo Akufo-Addo ene ye article 146 of the 1992 constitution into our ho kwan se obetro krata we ama Akufo-Addo. Now point 2 or say the legal basis of my petition is article 1461 of the 1992 constitution of the Republic of Ghana. For the avoidance of doubt, my petition focuses on stated misbehavior and incompetence related to the Chief Justice's administrative functions as head of the judiciary responsible for its supervision and administration under Article 1254 of the Constitution. Or say, adikudientia or jina so the ojina so edia kache Nana Addo Akufo-Addo say ompam Chief Justice Madam Torkonoo say Ghana Constitution no baby say oye Chief Justice ana oye nipa se bio constitution ama ho kwan say di dwuma bi na wendi a constitution aso esa ewo emra bi a ekire se wendi odwuma ye se ne etia o se egina sa constitution aso esa yi uto akonwa nti eno na ogina so e de aka che Akufo-Addo say ompam osono maame sorry ompam Madam Torkonoo a oye Chief Justice. Also, my petition does not arise from the Chief Justice's exercise of her judicial functions. Accordingly, the petition does not challenge any decisions, orders, or directive issued by the Chief Justice in the performance of her duties as a Justice of the Supreme Court, including those made to enforce judgments, decrees, or others in cases she has adjudicated. I fully understand, respect, and value the importance of decisional independence. Or see, Mr. President, krata ochramao no sebio emfa asama Chief Justice atena so edi or say ene de emfa ho or say obu Ghana mra obu eye edwuma a omedi no court eye Supreme Court any court aka or say sa the petition or three enye case bi a Chief Justice any Supreme Court judges bi tena so anase Chief Justice na tena so e na oka ho asem eno de sebio ohuni se eye edwuma wo so odi na eye petitioner ochro no eye nyoma mienu wodinka ase ana aka ho asem ene na ogina so intimema Mr. President wa adwirinya wo say atemkuruwa ana say judgment bi a Chief Justice ajage wa asem bi so ankoye ana say bi a webu asem bi asebio na eni ne kwan so say enya anu nti ena ochro say yenyi Chief Justice emfree de the position as the Chief Justice of Ghana. Okona nim no say and point 4 or say it is my understanding that upon the receipt of this petition, Your Excellency shall, acting in consultation with the Council of State, appoint a committee consisting of 2 justices, Supreme Court, one of whom shall appoint as chairman, and 3 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers. See Article 146 of the Constitution. Also, petition Mr. President, you know, so petition will become on sir. They also we because Ghana mrano echre say the petition say betu nsema ye wo emra bia wo say wudi so sebio eye article dey 1466 ene na echre dey wo say wo ye into onsaka eye petition we no emrano eda ho into di mrano so na yenhwe sene asem we no ebeko na all can o say emrano ne say so onsaka petition one dey also we ne say first of all e wo say wo ye den ufa eye judge fo mienu a sebio omo Supreme Court sia obete committee ana eye nipakuo bi a omo no mbehwehwe asem we mu no na constitution no kire e wo article 46:6 say e wo say ofa eye 2 Supreme Court judges e wo sa committee no so no now ena o say 2 justices 2 Supreme Court justices includes those made to enforce judgment, decrees or orders in case. No, let me go here. 2 Supreme Court judges, one whom you shall appoint as a chairman. Or say, Mr. President, Mbrani say, I will say, Supreme Court, Obeti Committee, Momasha Asemwima. Also, we judges me free Supreme Court. I will say, Bako and a chairman of Edian Sa Committee, no, and 3 other persons who are not members of the Council of State. It also Council of State in the one. So, Mbrani say, Council of State in Article 146 nature say, and this we nipa bia every Council of State. I will say, Ukoyi nipa. Bemian Sefri Abontinia, Omuni Council of State in Mukra, into 2 judges from the Supreme Court, Baku, and also a chairman of the committee, and I also Osako Fanipa Miensa, Omon Council of State for one home, and I also a yadiang omonka nipa ukofa nipa miensa beka ho a sa nipa na ni se omoka parliament ho eni se sebio omoye lawyers eni se sebio omoye council of state members or say o nipa bi omoye independent. They are not supposed to be council of state members. They are not supposed to be lawyers. They are not supposed to be they are not supposed to be members of parliament. You just have to take 2 Supreme Court judges, make one the chairman, and go out there and pick 2 or 3 people who are independent minded to be part of that committee to sit on the Chief Justice Assembly. So, now, it is my further understanding that the committee shall inquire into the petition and recommend to you whether the Chief Justice ought to be removed from office on the grounds maintained in this petition. I affirm my understanding that all proceedings herein shall be held in camera, and the Chief Justice is entitled to be heard in her defense by herself or by a lawyer or other expert of her choice. Or say, ebe kono say senya ye kɔ enim no e wo sɛ ɛyɛ deɛ asɛm we no wo make sure sɛ wobetumi ɛde ɛyɛ petition we ɛbɛma committee na ɛbɛyɛ 2 judges from the Supreme Court baako bɛyɛ chairman na nipa bɛyɛ miensa a ɔmo firi abɔnten ɔmo firi parliament ɛmfiri ɔmo nyɛ lawyers ɔmo nyɛ state council of state members saa nipa bɛyɛ 9 a na enum no ɛwɔ sɛ ɔde petition we ɛde ma ɔmo na ɔsi Mr. President ɛbɛyɛ fɛ sɛ asɛm we no yɛbɛ nyina yɛbɛhwɛ no TV so na Ghana ni bia ehu sɛ yɛnka asɛm ɛnto Chief Justice so ntinka ɛbɛyɛ sɛ nka Mr. President sɛ asɛm ne mu bɛda hɔ korɔgye ne deɛ anka Chief Justice na ankasa ɔbɛpene a ɔsɛ nka asɛm we yɛn nyina yɛtena camera mu na Ghana fo nyina hwɛ bi na yɛtoto nano na yɛnhu sɛ ɛyɛ petition we ngyinaso wɔ mu anasɛ ngyinaso nim ndwidwemu no ɛna ɔkyerɛkyerɛ mu no. Now point 6. It is therefore my understanding that Your Excellency, the President of the Republic of Ghana, Your Excellency, shall act in accordance with the recommendations of the committee. That is C Article 1469 to 1466 to 9. Or say, Mr. President, says our petition we no sebio ube make sure say committee no anyone kasa mwedi mraso because Ghana mrano dawa sebio wo president any sa committee ni say omo beye den omo di asem wechi emiako edi asem no krojin sene tie. Now afei na obekire the background the ogina so edi atro sa petition we the ogina so ensem a ogina so nti o se Chief Justice Madam Torkonoo eni se oye Chief Justice of Ghana eno na yesi amebeki dwem akyerɛw nti obi ase papa ya tro letter come Akufo-Addo se ompam Chief Justice edien pa na Chief Justice aye edien nginaso na ogina so aka kyerɛ Akufo-Addo se onti committee na yempam Chief Justice because we di abro why nyome bi a sebio ye constitution anase mbra ebo Ghana ho ban esabo judiciary no ho ban no we tietia so anase we mu mbra no. Now I feel over the original so the actual petition we and a friend of background. Now, background. Also request for the appointment of 5 justices of appeal to the Supreme Court. Or say, adhere baako Chief Justice here na etiamra was say gina so ede pamono e mane ko tenefie sebi oni pe bi be na nan ne say Madam Torkonoo Chief Justice of Ghana say onu ankasa de ne pe ebe appointi judge fo num bra Ghana mrano etia into see ingina so no baako edi nkan ne say Madam Torkonoo Chief Justice no de onu ane pe appointi na person appointi judge fo num Supreme Court na nkyerɛkyerɛm ni nie. By a letter dated 30th May 2024, the Honorable Chief Justice of the Republic of Ghana formally wrote to Your Excellency, specifically requesting the appointment of the following 5 judges of the Court of Appeal to the Supreme Court of Ghana. Or say 30th May. May 30th May 2024 afiwe mu no. Madam Torkonoo tro letter bre wo Nana Danko Akufo-Addo. Letter na o tro bre wo no or the judge for enum omo appeals court judges for enum the bre wo say sankofo no make sure say obema sankofo no abewura Supreme Court. Na judge for enum Madam Torkonoo petitioner na asem o kan no eye Kwaku Azar asem o kan say eye 30th May this year no Madam Torkonoo should actual secret letter the come Akuffo say oh judge for no mu we die ye fast the for Bobra Supreme Court itiamra article 146 to 9 no 1466 to 9 no itia o say sa judge for 9 ya no mo ye appeals court judges yi omunie 81 petitioner and I say Kwaku Azar and Mr. Kwaku Azar no wache wabo date into a very important date womb. Now, judge for 9 and appeals court judge no munie. His Lordship Justice Edward Amwakwa Santi J.A. Her Ladyship Justice Angelina Mensah Homia. His Lordship Justice Eric Balfour. Her Ladyship Justice Syria Pamela C.A. Kranting J.A. Her Ladyship Justice Efia Asare J.A. Also, sa judge for a numwe secretly. Madam Torkonoo extra letter come Akuffo say on making sure say obe present your mama parliament me de omode abahin Supreme Court. Ghana mrano adhere tia. Chief Justice enkwahye kukuo mu ntro letter nkoma president say president nipa numwe for Mobra Supreme Court. No. Into say we bi ni nyoma ogina so. Now time a Chief Justice extra sa krata ne koma President Akufo-Addo say on for koti kwan bi so na on for sa judge for enum wei embra Supreme Court emma no ono ana dwene mu no ochro note bi to so nyoma bi a ochro ka ho a kire se e wo se Akufo-Addo emma sa judge for wei kwan se bi ono na pese omoba Supreme Court. Commenter Chief Justice Gertrude judge for bi e wo sa letter no ni regarding His Lordship Edward Amwakwa Asante judge ba kwa na efe no Edward Amwakwa Asante no Chief Justice Torkonoo letter ne say no trofa no ho o say Justice Asante's term of office at the ECOWAS court ended on 31st July 2022. He was requested to remain at post on account of the withdrawal of Mali, Guinea, and Burkina Faso from the community. His current tenure is expected to end in 2026 or earlier when he is expected to return to Ghana's judiciary. Now, later no, Chief Justice Gertrude say His Lordship has provided. The letter goes on to say that, Osachro say, His Lordship has provided excellent leadership as President of the ECOWAS Court and will undoubtedly be an invaluable asset on the Supreme Court of Ghana. Chief Justice Sakratano secret letter come Akuffo-Addo say, judge your friend Edward Amwakwa Asante no. Adikudientia on Chief Justice instructed on Akuffo-Addo come with boom. Say and Supreme Court and say, Sir Judge no or ECOWAS Court. Na Madam Torkonoo say oh sa judge ne de mi amini pa no wa ya de say wa bod ho modin say mini pa say oba na oba Ghana Supreme Court oba be di dwuma aboaye ene na wo letter nim into say san nyoma we a Chief Justice Troye e wo letter nim no e na kire say Chief Justice na boapayo ni da ho e na all selected the Black Star players through the president to come to the Supreme Court. Or say regarding His Lordship Justice Eric Balfour and their Ladyship Angelina Mensah Homia, Syria Pamela Kranting, and Efua Asare. However, Her Ladyship, the Chief Justice, wrote that day. Or see, judges for an hour Canadian, Mukai Judge Balfour. Judge Balfour no catch them or the warrant at Thomas forever and ever. Mukai. Aha. Or then friend Judge Balfour. Yaniko appeals court. Or no na okanwa Chief Justice say by force. Or person offer kutikwan so edeniko Supreme Court. Inti judge Balfour na oka judge for enum no ho. First one they know ECOWAS court judge. Okan ho asem tro the reason tie Akufo-Addo Fanembra Supreme Court. Now for na aka no letter na Madam Torkonoo secretly come Akufo-Addo no. This is what she said about the 4 judges left. Or say all these 4 judges, and I quote, are currently working as judges of the Court of Appeal. Their work has been distinguished by outstanding services, courage, and competence. End of quote. The grave nature of the Chief Justice's role in requesting the appointment of the said justices to the Supreme Court became evident when subsequently social media published another letter dated 7 February 2024 from the Chief Justice to Your Excellency. Inti Judge 44 now can the Chief Justice letter no such from Akufo-Addo say, oh, we mu die. Wa wonim yankofo oma bom ho modin yie. Inti hwem Justice Cheba for on the warrant to talk Kevin Taylor sono into Sanko for Makano, making sure someone in a letter with no shim into a protocol list and a Chief Justice Torkonoo. I also oye neutral no okutani protocol lister or there come Akufo-Addo say for Mobra Supreme Court. Mr. P. Yeah, okay, so that's the letter, right? Okay, me team listen me for letter before we move forward. This is the letter now. The petitioner is talking about in the petition. My me for letter na yen twaso sene beya obi abehu asama ye ka no enye atro na yedi ediato Chief Justice Torkonoo. So this is the letter. Letter when Chief Justice etro koma Akufo-Addo a petitioner Kwaku Asare chechiri mu achire Akufo-Addo say we etiamra. Into your letter now, His Excellency Nana Addo Akufo-Addo, Osha top one, Honorable Chief Justice, date show 30th May 2024. Meaning the petitioner Kwaku Asare no, wa both date date no letter no actually say Chief Justice Madam Torkonoo sadie no. Since letter we ba abontin, Madam Torkonoo ba abontin kaka say enyo no secret letter we or the protocol list come Akufo-Addo say Omo Supreme Court. This is the letter. Osha, His Excellency Nana Addo Akufo-Addo, President of the Republic of Ghana, blah, 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 blah. Your Excellency, proposal for appointment of 5 judges to the Supreme Court. Chief Justice natural letter we come Akufo-Addo. It was intercepted. It was published on social media. The basis in also Chief Justice. Na odi protocol list ko akope nipa bi obetumaye dwuma bi amano Supreme Court na ye che no. You can see the Chief Justice, the protocol list in the secret letter he wrote to Adhere Nana Addo Akufo-Addo. I write to respectfully request that the following judges be appointed to the Supreme Court. This was a request. The Chief Justice, Catcher President said, Momumbra Supreme Court. This is dangerous. You have a protocol list in the Supreme Court and to become a Supreme Court judge. But the Chief Justice, Madam Torkonoo, did that. And in a petitioner now, what your letter come Akufo-Addo say? I was some many a pamano because when you do this, you have committed a crime. And the Constitution states it clearly. Article 1466, Article 1466 to 9. No, it is clearly say you cannot use that your position to influence positions to the Supreme Court. Inti clearly no, our reason and basis in tia what your letter come Akufo-Addo say. Pam Madam Torkonoo letter nini, that's the evidence. Now mommy anko back to the petition. Send a Ghana for ebe to me who said the ekosono enie. Now petition uko wenima. Or see, even on the 7th of February 2024, 7th February 2024, is captioned brief on the need for the minimum number of 20 judges on Ghana's Supreme Court bench. In the said letter, the Chief Justice stated that almost say 7th February 2024, the Chief Justice Madam Torkonoo sat through another letter. A letter now such a come Akufo-Addo no or stating reasons in tia and what say or no and making sure say judges almost Supreme Court no you move 20. It's the reason here. Now, ne protocol list say Akufo-Addo do munya beba ne say na ono no opese o move Ghana Supreme Court judges no etu the 20 opese o mu 20. America kakrake ye Supreme Court judges ye 9. And so Madam Torkonoo any Akufo-Addo atro mo letter ema omo ye plan say e wo say ye den ye move ye Supreme Court no judges no numbers no ekọ 20. Now tie letter na Madam Torkonoo Chokome Akufo-Addo no on the 7th of February 2024 no. Mr. S. Okay, so letter so me team ne dia ba I will show you that letter on February 7th. I will Chokoma Akufo-Addo no. I will show you the letter before I read. Letter ni. Thank you Mr. P. Thank you Mr. S. Thank you for bringing in this letter. Now me team ne 7 letter this is the letter Otrono on the 7th of February. Or Sakache Akufo-Addo. First letter the 30th May. Or catch 2022 no odin kan catch Akufo-Addo say on for 5 judges we mra and at 2024 7th February no or some reasons in tia also or person or move judges no to 20. Now this is the letter or Troye on the 7th of February 2024 na or insist say or person or movie judges no ko 20 where ye Madam Torkonoo ne terminal report na me read actually no. Honorable Chief Justice of the Republic of Ghana, 7th February 2024. His Excellency, the President of the Republic of Ghana, Office of the President, Jubilee House, it will share letter now, Madam Akufo-Addo, brief on the need for a minimum number of 20 judges on Ghana's Supreme Court bench. Into Akufo-Addo say, after the protocol list of 5 commanders on former Supreme Court, no, appeals court judges, no, or Saba 2024 be man reasons in tra or person or sa expanded judges almost Supreme Court to 20. Now, this is the letter. I'll say, respectfully, I write in reference to our previous discussion on the Chief Justice's proposal for an increase in the number of justices of the Supreme Court of Ghana. Kindly find attached a paper justifying the need for the request. Thank you very much. Madam Torkonoo, Nidine Shasiano, into Chief Justice Nankasa Akufo-Addo, say, the reason there's a need for a Ghana judges now Supreme Court, no, or no, after bringing 5 protocol lists, no, from appeals court, no, or sa insist say or say my judges no could do 20. Yanko enim, yanko kind petition in the womb. It's on petitioner, no, he was telling you evidence enye busremuka or show evidence any embra Chief Justice Torkonoo ebuso. Now, no point 13. Or say the above quotation suggests that there has been a previous discussion on the subject between Chief Justice and the President. It is already letana quotation or any caption say Chief Justice Akufo-Addo didn't plan it. Now they wanted to make it official. Into petition say so already letter here only say President Akufo-Addo name Madam Torkonoo trase and planning say the protocol list of 5. Madam Torkonoo de bebreno na wa pass omo de omo ba Supreme Court owia na wasa de krata ba injina so a opese obie judges ni mu more emom ye 20 e Supreme Court until they had planned it. And a petition say so ready documentations na follow ni nyina e kire say Akufo-Addo ne Madam Torkonoo no omo tenas na omo plan say omo the protocol list be ba Supreme Court omo wi na omo say bie judges ni to 20. Now petition and call him no say point 14. Of concern to your petitioner is the fact that both letters, one proposing an increase in the minimum number of justices on the Supreme Court of Ghana and other requesting 5 specific judges to be appointed to the Supreme Court, were written on the letterhead of the Chief Justice and clearly expressed itself as the Chief Justice's personal request on the matter. The letter did not refer to any consultation or involvement of the Judicial Council, of which the Chief Justice is a member and within whose constitutional mandate it lies to deal with matters relating to the appointment of justices of the Supreme Court. Or see, petitioner said, Usha letter Mirina Chief Justice Etrokoma and Nana Akufo-Addo. Let me put it on the screen. Senabeya Obetiasie. Usha these 2 letters are Madam Torkonoo Etrokoma and Nana Akufo-Addo now. You can see clearly say the letters were coming from the office of the Chief Justice. Now, the money who say you be a for the Judicial Council. Judicial Council no embrasha almost say you per se you appoint a judge phobia at the Supreme Court. I was said Judicial Council na trase. Now omuyem pensemu ehwe mu mra edwindwene ho etiase say we die a good decision and I say a good decision. Judge we qualify and so qualify. Petition and natural petition no Kwaku Azar catch Akufo-Addo say. Uhwe 2 letters na Madam Torkonoo Chirobra first one say Sebio or the 5 protocol list on one kasa hand-picked judges. And the second one or Troya or say the reason why into a person obey judges now was Supreme Court to 20 no. Usha letter ni mienua letterhead if you on one kasa office. There is nowhere in the letter as cited say she consulted the General Legal Counsel. And I say she consulted what we call where's the name? The Judicial Council. There's nothing on this letter, sir. Actually, say the Chief Justice consulted the Judicial Council. It means to say that decision was solely taken by the Chief Justice herself, which is against Imra. So the Chief Justice is now Mugabe. The Chief Justice is now an authoritarian. The Chief Justice is now running the Supreme Court or the judicial service and the judicial system as her own property because she's sending letters to the Jubilee House with her letterhead, and in the letter she did not state anywhere that she had consulted the Judicial Council on this matter. So clearly the Chief Justice has breached the law. She is basically being an autocratic leader. She is misbehaving. That's amount to misbehavior and it's countermount to the sacking of the Chief Justice. This is the petitioner's reason. Until Nana Dankwa Akufo-Addo or say Opam Madam Torkonoo, and he's not just stating the things. He's using facts. He's using articles. He's using the constitution and making the president understand the say. Emrana Bogana Hombane Chile say or say Chief Justice taking a say steps way. So when taking steps way and nobody is supposed to allow her to be as to be there as the Chief Justice of Ghana. Now, Yanko point 15. Point 15 in the petition. Team, are we good? Thank you, team. Thank you. You know, say we do live production. When I need something, the team will pull it. So that's how it works. Now, when you go to point 15 in the petitioner page 3 out of 19. Hey, asamoho. Point 15 say, your petitioner is further concerned by the reference to an earlier discussion between the Chief Justice and Your Excellency the President on the proposal to increase the number of justices on the Supreme Court. Your petitioner also notes that the question of minimum number of justices on the Supreme Court is settled by Article 1281 of the Constitution, which provides that the Supreme Court, and I quote, the Supreme Court shall consist of the Chief Justice and not less than 9 other justices of the Supreme Court, end of quote. Or see, petitioner say, say Nana Dankwa Akufo-Addo wunim se emrada ho a ekire say your Supreme Court nanka say de I say a Chief Justice any 9 judges o kan homa ne 10 and I was omo at the same time inti day na Chief Justice Madam Torkonoo a onum Ghana mra nyina no etumi tro letter bra ka kire say o pese o expand adhere constitution e say ketin. These are entrenched laws. Constitution e say I was say a Supreme Court no at every given time or say judges 10 ho Chief Justice plus 9 judges. Now, you, the president, who is a lawyer, a so-called lawyer, who knows the law, so Chief Justice actually let us say, Edia bro, say, even though she knows the Constitution states this emphatically that you cannot exceed 10. No? Why did you, at the end of the day, not raise any concern into the petitioner now or letter come say a shocking? The president does not respect the Constitution and the Chief Justice does not respect the Constitution because it has been stated in the Constitution. So Article 1281 or say at a given time no you have 10 judges at the Supreme Court. Chief Justice plus 9. In the Chief Justice to let a president to say, Mr. President, me person me 20. It means somebody is taking advantage of the Constitution. Somebody is abusing their office. It's either you, the president, or the Chief Justice. Now, the Chief Justice has to go because the petition is directed at the Chief Justice. Now, let's go to point 16. Ghana for this is how it's going to be done from today. Sani ebeno yadeno kure na bebo Ghana ho ban se ne be ya obi ntumi nko twist nsembia enkoka nsembia ntu obiaso. 2016. The plain meaning of Article 1281 is that the minimum number of justices for the Supreme Court is 10. Thus, an amendment of the Constitution is the lawful way to change the minimum, not by a private discussion or communication between the Chief Justice and the President. It is Parliament that has the power to amend the Constitution, Article 289 of the 1992 Constitution. Into petitioner catcher Mr. Akufo-Addo, Ghana mrana kire says sa part of the Constitution, Article 1281 of the Constitution, I say it was say at any time biano yet Supreme Court no judges all include the Chief Justice yet 10 no. It is only amendment. Yakasa amendment. Sa part of the Constitution 128.1 no. It was say ye sacred ye di and saka any of an amendment. Ye sasha ni biem say be dane ne kakra. So far amendment bi ambaye. And at the end of the day, say some run required and Sabeka, I can say judges 10 or more Supreme Court, I was say the 20 I was see this a day, and Mrano echo do parliament, not parliament at deliberate near to Swaba and Sunny Ajah to say, you per se expanded the number of judges at the Supreme Court. But Social Lieutenant Chief Justice Torkonoo Akufo-Addo, it is looking like they have ignored the procedure and process. And it is beginning to look like a personal vendetta, a personal agenda. A Chief Justice Akufo-Addo are conniving behind the scenes to slaughter the Constitution of the Republic of Ghana. Into the petition, I say, what he is seeing and he say, You, the president and the chief justice, you have connived because from the correspondence, from the letter, no, the chief justice is basically flouting the laws. She's going against the constitution of the republic. Chief justice now or the Supreme Court or interpreting constitution, no, she is basically doing what? Fucking the constitution. She is basically murdering the constitution. Or Danny who say I am interpreting it. Or Danny who say then she is murdering it. And then a petitioner, Asare say, Nana Danko Akufo-Addo, what we are seeing, no, it is looking like Chief Justice no on the Alpha Ghana judiciary say more personal property. Now, point 17. Further, your petitioner has reliable information that a meeting of the Judicial Council held on 14 June 2024, the Chief Justice expressed her desire to increase the number of Supreme Court justices, whereupon the Council advised her ladyship to pursue broader consultation with other institutions on the matter, especially the Parliament of the Republic of Ghana. Or say, Mr. President, petitioner said, Mr. President, the Chief Justice at a meeting a course between the Chief Justice and the Judicial Council no, on the 14th of June 2024 no, was stated amount date. Chief Justice echo meeting as no crazy say, oh, me perceive me increase the number of people on the Supreme Court bench. And the Judicial Council focus the Chief Justice. Sa same way, and yet is the sa because constitutional a barrier a jinaso. Ain't in Kebeya and Chief Justice. Ye ending kind and consult Ghana for yen consult parliament. Ni any parliament internally pense mu. Send ye beya ye bet me to sa na more way and so Chief Justice NTA. I'll see meeting also on the 14th of June 2024. Meaning at that meeting, the Judicial Council told her that if she solely take that decision, it is against the law. So she knew that the intent was to commit a crime. From what the petitioner is saying, Chief Justice had an advice from the Judicial Council telling her that do not even think about it. But the Chief Justice, upon all the advice she was given, in this point, we will say the legal advisors of the Chief Justice was the Judicial Council, but she ignored their legal advice and decided to take her own decision. And no enemy who said she flouted the law and became an autocrat and decided to subdue the constitution to benefit herself by selecting 5 individuals she thinks are her boys and girls that can work with her. And also, her herself decided to expand the number of judges on the Supreme Court bench. It is dangerous. It means the Chief Justice has stabbed the constitution in the heart. And as a person, personally, she wants to run the Supreme Court like her own business. On the 14th of June, Judicial Council for catch and say, hey, adhere we dangerous. We need broader consultation. And even after the broader consultation, I will say you call parliament, any parliament, and some person will be president. But Chief Justice told them they should go fuck themselves. She knows what she's doing. And in petition, and they say, let us sound to say when the president and the Chief Justice wedding come with Chile and a more plan. Petition point 18. Point 18. The petitioner, the Ochema, the Kudientia was a Chief Justice, a Pamano Enie. Mr. S, what again? Which one is this? Okay, so my team is a constitution in Chiramo. Article na the petitioner Edeka the Supreme Court. How many judges is supposed to have at a given time? We need to make sure the facts are stated on the show. Now, so Ghana, chapter 11, the judiciary. This is what it says about the number of judges are was etna Supreme Court and so. The petitioner has a case. Now, 128.1 na petitioner estate the petition no or say constitution say the Supreme Court shall consist of the Chief Justice and not less than 9 other justices of the Supreme Court. In the Constitution, it makes it clear, and Chief Justice Torkonoo, who is supposed to interpret the Constitution, knows this. Even at a meeting where the Judicial Council advised her that do not do this without broader consultation and also consulting Parliament, she still flouted the law, went against the law, and decided to go behind the scenes to work this thing out with Akufo-Addo to bring their shortlisted judges to the Supreme Court. The petitioner is telling you, say, Emra ewoho a Chief Justice abokro no enie inti yengina so ne pamono. Let's go back to the Constitution. Thank you very much, team. Now let's go back to the constitution. Hey, let's go back to the petition. Petition point 18, page 3 out of 19. Hey, I remember Debbie. At the said council meeting, the Chief Justice did not disclose the fact that her desire to increase the number of Supreme Court judges had been the subject of a previous discussion and communication with His Excellency. This fact became evident only after a letter dated 7 February 2024 from the Chief Justice to Your Excellency appeared on social media. It follows from these facts that the council had no knowledge of her involvement in the attempt to increase the minimum number of justices beyond the constitutional specified number. The petitioner say, even meeting the course no na judicial council for nimu say time na muti meeting na say kasa asem na Chief Justice krampo din ka letter come president until say letter no krampo ba abontene it Chief Justice no otutu anoma e na o de ko kire judicial council for say otutu anoma no wie na say anoma ba enie na oyo mo krokro de John Abrank also consult your first no we didn't get taking the decision awie and son obetutu anoma ho achom say oh anoma we bola bed and I say antro here because she had already connived with the president behind the scenes because I will check the date of the letters now those days clearly say the Chief Justice had already written to the president before even meeting the Judicial Council in June 14 2024 meaning on February 2nd now or church and a letter no any a year the previous one in 2022 no that means that before we got to June no not Chief Justice didn't catch letter come Akufo-Addo and send otutu anoma how catch Judicial Council say oh me person can me expanded the judges. Chief Justice had already broken the law. She's already broken the law. We boom run so that and what Oba make sure say Judicial Council at the end of the day will be part of the law she has broken because you see she needed an accomplice. The Chief Justice knew because I know she knows the law. That is why she's at the Supreme Court. She needed an accomplice to help her in law and I say in investigation. Freddie alibi. The Chief Justice needed an alibi. She needed somebody that their words will sync with her word to protect her later when she's caught. So she used the Judicial Council as an alibi. Senebeya some way back. Chief Justice Becker said, oh, I was at the meeting. So I already told them. But the letters and the date on the letters actually exposed the Chief Justice. Say she actually took that decision before meeting the Judicial Council. So she had already committed a crime. But it was an afterthought that, okay, my committed crime, let me now implicate the Judicial Council. Senebeya, I cannot be sidelined or isolated and punished. So that meeting, she went and basically threw in that suggestion. She had already taken a decision and the evidence is in the letter. Now, page 19. Mijujum. The article 128 clearly states the Chief Justice must go. And this is the petition to the read. Number 20. The Constitution requires the President to act on the advice of the Council in consultation with the Council of State when nominating Supreme Court judges for parliamentary approval. The Chief Justice's elaborate scheme of requesting the President to appoint specific judges and later presenting these names for the Council approval subverts the constitutional scheme and converts both the Council and the President into rubber stamping her preferred judges. As it turned out, the scheme was fortuitously undone by the Council's concern about the timing of the nomination. Now, when the petition is being considered at any stage, members of the Judicial Council will be subpoenaed to testify on the matter. Petitioner say be judges for and I say be judges at Supreme Court. The Constitution requires the President to act on the advice of the Council. I was a president in every Council of State because me person judges for be adding Echo Supreme Court. Na mo na mo Council of State. Mombra na mo ne member fa ho adwene. Nipa num mo mo saying, mo adwene mo saying, ansana owia na sa eye de sa eye nominees na Supreme President be or the akọ Parliament. Or the Parliament na Parliament for also avert or omo vert omo we answer omo approve answer na job to some go Supreme Court. But this is the case whereby the Chief Justice at the end of the day she basically decided to put together a plan that will cut out this process, a plan that will be between just her and the President, because She just wanted the president to say yes, and then they'll move the people to the Supreme Court. Abra, the Chief Justice is supposed to follow the due process, because when you take out due process, everything becomes corrupt. That is why due process, normally, when you are doing things and you take out due process, whatever you do, that process becomes corrupt, because the due process will do what? Will refine the journey, will refine whatever you are trying to get. In this opposite, uye gold. So ko bobo bana or sabu bana or the process and sana ko do baby a friend way gold. You just pick a rock, it's an ore. There's nothing in there but to say way met ton. You need to grind bobano or crash bobana. Now the coffee machine, na machine na nyam no mana coffee to powder. Or we are no shanke. O shanke na uchasu ya and sana beda nisio. Now was adia good so no say chimu and sana the murder tum what the murder tum and sana you go in pay. It is a we ignore that process now. So gold no worth $2 million I to worth 20 Ghana, because the due process, when you skip the process, that thing does not become valuable. And that is what the Chief Justice did. She cut out the due process to benefit herself and also the president. In the petition, no air can't talk to us say, oh, Sir Chief Mr. President, mo pese Ghana for nyina hu no kura wo ma e wo se omo wari he judicial council no e wo se ye petition o ma na se ye subpoena omo e wo se court she omo no omo ba committee de nimbeji tum say Chief Justice yes sa na se wanye sa. I think the petitioner is trying to also give the Chief Justice some room to basically clear herself. Say judicial council for no yes subpoena omo na omo ba court na omo be di trial ye nyina nim say we di trial under a subpoena, you know what will happen. Mr. Petitioner, Mr. President, the Chief Justice said, Asaba Yaki nyina eboa, you betima subpoena judicial council say letter we about the bay meet you omo and correspondence lecture saying or say he's open. In the Chief Justice Madam Torkonoo or say oba na oba church nsemu. Point 21. Oh, see, over Kevin does galamsey because of the way he's breaking it down. Say if you boss be a galamsey boy. Point 21 said the Chief Justice's request for the appointment of the aforementioned judges to the Supreme Court was done in brazen violation of the constitutional rules for the appointment of justices of the Supreme Court, amounted to abuse of her office, and was done without fair and or reasonable criteria. Into a say 21, the Chief Justice I in some Makachiri the Chief Justice was abusing the office. Adio ye need the hon wodi bone into enono kyerɛ sɛ ɛwɔ sɛ pamona na yi ne to akonwa. Point 22, the Chief Justice request for the appointment of the point 23. Petitioner Bibi point 23 or say the Chief Justice, as the head of the judiciary, must understand that she has no direct role in recommending individuals for appointment or promotion to the Supreme Court. If the Chief Justice makes recommendations for the promotion or appointment to the Supreme Court, it strongly indicates either a shocking lack of understanding or utter disregard for the constitutional process and established promotion procedures. Further, the Chief Justice ought to know that she cannot have a side deal with the President to raise the minimum number of judicial or justices to the Supreme Court, sidestepping the minimum that is specified by the Constitution. Petitioner, Mr. President, the Chief Justice, no, say, or take a decision. Now, no one can recommend nipa. Now the bravo president said, Mr. President, Masanko for Embra Supreme Court. Etiam Rado Kondo. In fact, sir, Emrana Chief Justice FR so all recommended nipa edia bro, sa obe promote omo, sa obe di ombeba Supreme Court, sa obe momu di endibrebiano, Ghana mrano chre, especially say Chief Justice any president kasa say or percent or expanding the number of judges omo Supreme Court bench in this one. Abra when use due process. Now it means to say the Chief Justice herself, no, need daho and we bugana mraso because it's stated in the Constitution. Say you cannot do that. Article 128(1) clearly states it. Say you cannot by yourself behind the scenes with the president promote or nominate people without using due process. Into petition and say sign your way says the Chief Justice not to mra we bu mraso. Se Ghana your maya ye pese mra ye adwuma or some Madam Torkonoo ye pamono. Now ukwa ye frɛ B arbitrary reconstitution of panels and transfer of judges. Because you say on my point o gina so e de aka se Chief Justice ye yin to akonwa. First one aye kan no e na your friend request for appointment of 5 justices of the appeals court to the Supreme Court. in some no wakano reason dia baako no. Now waba another reason tia also pam Madam Torkonoo, and that reason here arbitrary reconstitution of panels and transfer of justices. Or say Chief Justice then to me at the judge phobia or nankasa di trim onim raso na wasesa judge phobia egu panel bi so watikuo bi na nankasa mom di dwuma bi or say eno so ka ho tia o say Madam Torkonoo ye yi ne to akonwa na mom yan kan de wa ase. 24. There have been reported incidents of Chief Justice's direct interference with duly constituted panels with no explanation or public interest reasons for so doing. We consider the reconstitution of panels to be beyond the Chief Justice's administrative power and amount to direct interference with the impartiality and independence of duly constituted judicial panels. Almost say petitioner say you may be so close to Supreme Court. Chief Justice to be change judges anyhow. Sebio or the Chief Justice. Now you to me the nipa miansa kotena appeals court case bi so. Ade to me chano pa no asesa omo without even going through the process. I was here. Chief Justice ade bibia hye den sa. Obi to me kotena case so oh ade achi aye kotena case so endu ahomache for ne a friend say on free case so ebi wo kwa to me the phone calls e ka chom say case no menko ho o chena obi abehya wanan o say saa nyoma ni nyina kire say Chief Justice no or abusing the office and the evidence are there. Now, 25, the Chief Justice's constitutional and or legal authority to constitute and reconstitute panels for the hearing of cases must be guided by the constitutional and common law principles which regulate the exercise of such power. And so is the power to transfer judges and other officials of the services. In the Chief Justice, even though ordinary Chief Justice, Supreme Court of Ghana, I was say Odim Rabiso. Say about transfer of judges and I say the judge phobia assembly so or so free so and I nipa bi so mutena case judge phobia so omutena appeals court case bi so I was say odim raso say oya Chief Justice na nkyere say obetuma tena fie atamfo na free judge of phones say case we free so no, it does not work like that. It has to go through a process. But Chief Justice no consistently no omo wu say saa nyoma no onye otumi body sirem no agasa asemesi free case we so we nkodo obu a wodware no pa odum say case won net so ondu court we say o Chief Justice afre say wo de wutumi tena case no obi mbra and their evidence or the aka the petition no a prove say e was Madam Torkonoo ya pamono. Now when you go to point 26, the fundamental inability to distinguish between the exercise of her administrative power and interference with the panel's judicial work confirms her incompetence quite apart from the dangers that it poses to the integrity and independence of the judiciary. Inability to understand or perform the duties of an office inadequately constitutes incompetence. Enti osi adikudientia okache president to say the two things are original so say and from Chief Justice are back where incompetence and say so but I had the lapses in her work. How she's not able to make sure say due process is followed, and also how to make sure say administratively conducting the judicial affairs in our courts, the inconsistencies and the unprofessional attitude of her, it amount to incompetence, ama workflow, and judicial service, juma nanka say ekoso and sisine naso. Into when you say Chief Justice Madam Torkonoo is incompetent. Sebio oni sa nyansa ho kana obetumi edi Ghana Supreme Court enim edi make sure say Supreme Court any court ehihye na se nyina no omo die dwuma amana die esi totin into ogina sade o chaka Mr. President say upon nyoma we state no sa nyoma we nyina chere Chief Justice Madam Torkonoo oye incompetent dwuma dia odi no wabe selfish wabe arrogant wabe somebody who has become an autocrat in a democratic dispensation. And the petitioner said, no, Mr. President, Sama mi way petition way chesa was here pamono. I was here yin to akunya. Point 28. The Constitution. Now, point 27. It is my contention that reconstitution of judicial panel is the ultimate way to interfere with or control the impartiality and independence of a panel's judicial work, guaranteed by Article 1272 and 1913 of the Constitution of the Republic of Ghana, 1992 Constitution. Petitioner said, Mr. President, only the Ghana branch and PFA say Chief Justice started in Sakaka judge for any judge form to the case so reshuffle mo move without going through due process. The they say it might be a friend of crow ana crojin ana fair trial. Said the dear some soko pepe yosona obiade na koma pakofie no or say the moment a obenya chief justice or than the judges or turn them ekasa we nkwa ha no ema den asema sebe ehuni se ewo se ye no kore na ntumi nya no kore efri se ade be chime akodi asem na yenim se judge we na atena asem we so 6 years ana 6 months ana 2 years na ade be chime be court na ade chie na judgment beba na ekasa assistant judge we ye the judge we abeto so na it means say judge foforo na ye de ba no na ye bia ya man agenda bi se ombeye. Because the judge now otuna case in this one for all these years or months, no. So on one a case in na adentina sa judge no and to me any day incomplete case no. A typical example is the Hunyuniga case. Opuni a case no. At a point, they delay the case to make sure say Hunyuga will get to a retirement. Send a bear mobile to me another judge who will be dancing to the song of the Jubilee House. And there are so many cases Asia at a point Edru say a judgment tibeduno near you judge in Ubusa the Chief Justice she does not give any reason because there are some people who think say they can run the Ghana judiciary the way they want. But petitioner say society is here. Emma peyo any impartiality any say the idea some krojeno embaso if you say ebasada na insem na wo court na say nipa bi na sebio omo edinu amana eden akọ omo side no who is the Chief Justice attitude no sa nyoma na edeba enu na ogina so say yempam Madam Torkonoo. It's basically abuse of power. Now point 28, the Constitution is clear that no person, including the President, Parliament and the Chief Justice, shall interfere with judges or judicial officers or other persons exercising judicial power in the exercise of their judicial functions. That is in Article 1272. Thus, the reconstitution under the guise of exercising administrative power is a glaring abuse of her office and a fundamental misunderstanding of the boundaries of the Chief Justice's administrative authority. The abuse of her administrative power to interfere with panels' judicial functions meets the threshold of stated misbehavior. Inti enena obon the tough say the Chief Justice say ya ordering in psychic judges we kwa ha ade be chiri be ma final judgment to free we measure ho or say sad no at the end of the day what it does is say so kokan Ghana articles no and as a constitution article 1272 no clearly say judge be ana Chief Justice sana what she is basically doing in the say she is not exercising her duties well. What she will use an argument to say what she's doing in the say yeah the juma, but in the process of doing that she's abusing her office. To say a thin line between magic and miracle. So when you're very clever, you will not understand magic and miracle. Magic for a short period. Miracle is everlasting. But obia weji say magic is miracle. That is why obetumi abuse office no but obeka says she's exercising her duties. But in the process, when you look at the detailing, you could see say she is abusing the office and what we call justice. She is not helping justice to be meted on the people. What she's doing is she's interfering in the people who are supposed to sit on cases, know the merit of the case, and pronounce legitimate judgment. She is interfering in those judgments, taking away justice from the people. The petitioner is saying, article in the Ghana's constitution, say Chief Justice be yes, sir. Or boom ranoso or near the constitution or tietia, she's abusing her office. Basically, that's what the petitioner is saying. Now, the petitioner Emma instances a man kasa asem and o state the opuni trial and am kan me pona menye hu Mr. Asare ekache Mr. Akufo-Addo say examples of what Chief Justice Aya actually say or interfere in reconstitution and the panels on cases or see this one of the specific examples opuni case or see the ongoing case involving Mr. Opuni, the Republic versus Stephen Kwaku Opuni, Sedu Agongo Agriculture Ghana Limited, is a glaring example of the Chief Justice's abusing his administrative powers to reconstitute a duly constituted Supreme Court panel that is seized of matter on the judicial side. In this case, Justice Hunyuga, who presided over the matter at the trial level, proceeded on retirement. Now, the trial was reassigned to Justice Kwesi Anochijima, who at that time presided over a division of the High Court in Accra before which the case was placed. The court presided over by Anochijima ruled on April 4, 2023 that the trial should start afresh, that is de novo, considering the need to observe witness demeanor and the fairness concern raised by the defense. This has also been the practice in criminal trials, in contrast to civil trials where the parties had been optioned to adopt the proceedings or start the trial de novo. This common law positions is reiterated in the Republic versus High Court, that is Criminal Division, ex parte Stephen Kwaku Opuni number, and he put in the motions and all that. Judgment delivered on 24 January 2023. Or see a typical example, a Opuni case, no. Petitioner said, Mr. President, Ubejedi say Opuni case, no. Justice Hunuga, omu delay case na mani bedru ne retirement date. Justice Hunuga call retirement, no, and a Chief Justice catch the judge for your friend, no. Eye Kwesi Anochijima say onko tena case no so. Sa judge no betina case no so and a Chief Judge catch a judge and say on restart the case no from the beginning, from de novo. Meaning, their witnesses in betina for over 5 years. Justice no study body language, study contradictions, study the inconsistencies in the defense and the criminal the prosecutor, whether their witnesses and all that, you know. Time Justice Hunuga echo retirement and Chief Justice Torkonoo ekache Justice Jima say ko now go tena case ni so start the case ni from afresh. Remember time na Justice Hunuga ewo case ni so no na edru baby a ewo so omyeden omuma Opuni bie ni defense na Opuni den ekache Ghana for say this is his case. But side new judge ne ba no case dabi because remember sa case no and attorney general no witness na oyedwuma okoko board page no ho court otwa atro Justice Hunuga ka kire sa witness na wa page no ho say yes I know say you have committed a crime. Remember so court na say us jinsie na say o ka asema insie na wudi no kire say eni say wotwa atro in the Opuni case no attorney general no witness baako edi tro o case nim ema Opuni lawyers no ehu atro no ema judge gitum say atro and so Hunuga ka say or the attorney to or sanko punishing nipa no either so be jail no or say that be or train na owie case ni nyina wa be so be jail na. That is against the law. The judge was supposed to take action because the person had sworn not to lie. So in the middle of the case or proceedings you be say what katro e was said na the law says say I was a judge to take immediate action but Hunuga anye. After all these things, you know, Hunuga say or call retirement, or say papa we buy no, and cause papa we tina case no so and cause witness from the attorney general no, na cause say jail no, and so papa na Chief Justice Torkonoo didn't buy no, say oh, yan sanko start case no, meaning the crime that the attorney general's witness committed during the trial no, that crime will be quashed away. Next means say bonina odi no yabog bonina tugu, and no ni sa nyoma na the petitioner catch Akuffo say. Sa nyoma wey ene kire se Madam Torkonoo edwuma all ya ode ne nsa keka judge for move things around no nim behavior no it tantamount to incompetence, and also she is basically running the Supreme Court or the judicial services like her own property. Now uko another pointer o make here reconstitution of panel for the hearing of Dr. Opuni's appeal. Also Opuni case no edru point to be no omo appeal e mani kopie Supreme Court mokai that was the time na Attorney General Godfrey Damemo almost started say omo skirmishes no. Now I say these are some of the reasons in I was a Chief Justice Madam Torkonoo ye pamono. Now which one is this? All right. Dr. Opuni's legal team, led by lawyer Samuel Kujo, filed an interlocutory appeal at the Supreme Court on July 7, 2023, arguing that the Court of Appeal erred in its judgment. Several months after the appeal was filed, parties appeared before Supreme Court on January 17, 2024 for a hearing. The court, presided over by Justice Mariama Owusu, along with Justice Kwaku Asare, Emmanuel Yonikulendi, George Kingsley Kumsin, and Henry A. Kofi, ordered the parties to file written submissions. Now, on May 8th, 2024, the Chief Justice controversially reconstituted the panel hearing Dr. Opuni's appeal, presiding over the new panel, which included Justice Mariama Owusu, Henrietta Mensah Bonsu, Kwaku Asare, and Ernest Gau. Only 2 of the original 5 justices remained. Lawyer Samuel Kujo objected to the new panel, citing Article 1573 of the Constitution, which stipulates that a judge or panel cannot withdraw from a case after hearing argument until judgment is delivered. Or see, the reason why Chief Justice could say a permanent and say, open case, yeah. There was an appeal. Judges are now also appeals so ometie and komobabeti appeal of opuni case, you know. All what happened was adhere case no na Chief Justice Madam Torkonoo e de onu ankasa ne tumi e judge ni bi se free so we yi ba mi ense free so anamienu e na ode onu ankasa no judge fo abehjem judge ode onu beka ono ba ko ye MPP ni judge de ko Supreme Court e be hu se na MPP card bearer member gawu into see sanyoma we Madam Torkonoo ye ne clearly say she has become a political judge. She is basically abusing her office by sitting behind what we call administrative duties. But you can see clearly say she is infiltrating, she is touching the process. She is basically abusing her office by bringing in judges. She thinks that when there's an appeal case, you know, I was said judges in the now, some of the judges are not with cases, so they complain, they say, Embrani clearly say, Chief Justice, you cannot take us off the case. Appeal, no, because you can only do that after we have heard the appeal and make judgment. But before that was about to happen, no, Chief Justice Madam Torkonoo catch on some free case, no, so and overnight, no, on one of the judges me and Sabeshemu and no kahu and clearly said the Chief Justice. Embrano clearly states say Article 153 say the Chief Justice Constitution say so yes sir. Why abuse Embrano? Why they was saying you to akonya if you say unya nipa ubumra. It petitioner say when na original so catch Akuffo-Addo say mami we also pamono because the Constitution states it clearly and the facts are there for everyone to see. So at this point, petitioner like Mr. President, mami we she is not supposed to be the Chief Justice from tomorrow. Now, when you go further, there is another case or cite or catch the petition, the Ablakwa case. Or see, the Chief Justice misconducting who the Ablakwa case. Then see then a Torkonoo then Emma petitioner Mr. Asare. General Swaka Madam Torkonoo is not fit and that the Akuffo-Addo should fire him. Sorry, fire her. The Ablakwa case, sorry. The Ablakwa case. On the 25th June 2024, lawyers for the Honorable Member of Parliament for North Tongu objected to a reconstituted panel of the Court of Appeal. They contended that, to the best of their knowledge, the panel to which the case was assigned are Senior Jamefe, presiding judge, Efia Sewa Saribotwe, and Acha JJA. They, however, observed that the panel had been reconstituted by the substitution. They, however, observed that the panel had been reconstituted by the substitution of Jamefe and Acha JJA for Pamela Cranting presiding and Kwaku Akabwa for JS, leaving Asaribotwe as the only justice of the original panel. The reconstitution panel dismissed the objection, holding that there was no evidence to suggest bias as the basis for the reconstitution. A Ablakwa case, no, at a point, Judge for no motiso, na omutie case, no. Adhere got na case, no. Nipa na omuka case omu ya be for no. Chief Justice Madam Torkonoo di onwani to me, omu free case, so another set of judges, ka case, no, omutie case, no, omunim where the case started from. Chief Justice Madam Torkonoo, a Ablakwa case, no, she committed the same crime. So it is looking like it is a behavior of the Chief Justice. She does what she wants, and basically she gets away with murder. She gets away with murder every time because at the end of the day, no onim say so commit crime no cry. Nobody is going to sack her because she, from the beginning of this petition, you could see her collaboration, her behind the scenes secret letters with the president. So she's basically like an autocrat leading our Supreme Court. Now, subsequently, however, evidence emerged that Justice Jamefe was initially empaneled to preside over the matter, but was written to return the docket to Chief Justice Senior Jamefe. Subsequently, however, evidence emerged that Justice Jamefe was initially empaneled to preside over the matter, but was written to return the docket to the Chief Justice. Justice Senior Jamefe will be subpoenaed to testify in the matter. Inti omu say, or catch Akuffo, Mr. President, as same way Justice Jamefe is there. Say committee no who putting it together, he can be subpoenaed to come and answer. Said the American me boa na say me boa because Justice Senior Jamefe no what happened and they say later no omu nyina be hu say the role no Chief Justice Geoffrey ni nsem and odema another judge. Chief Justice reconstitute the panel no Emma at the end of the day no credit but that say Chief Justice did that by her own will. Inti subpoena the petitioner ne kache Akufo-Addo say committee no putting it together from no mun subpoena Justice Jamefe no make say dia me came me boa na say me boa o tu evidence or facts or nipa also moba ebe kire say the okani nyina no no kre e was Chief Justice no ya pamono. Now also stating another case which is Republic versus Elisha Mahama and two others. Sorry, Elisha Mahama and two others. Into now we stating cases are say the Chief Justice no at the end of the day no or day obumraso or reconstitute panels or the nsaka judges or positions obi to meet cases where case ni ba be ready no you know the on confirm show say ni nyina no constitution is stating it clearly waka che Mr. President say what committee na Jamefe ni adade nya umbetube supini omo so ombra said the all can esiye anase ensi. Okay, so osade another point by ya or say when the engineer so enfam Chief Justice or say usurping the functions of the rule of court committee. Now, dear now watch your point 47. 7 out of 19. Mr. P, Mr. S. All right. Now, in April this year, 2024, the Chief Justice issued about 10 practice directions to regulate some aspect of practice and procedure of certain courts in Ghana. This function is by Article 157 of the Constitution reserved exclusively to the rule of the court committee. Almost say April this year, Chief Justice issue some practice direction. Sebio or the call out to say court na Ghana no. Regulated some aspect and practice and procedures of some of the courts. Now, Article 157 of the Constitution, it say, and yet Chief Justice no. It is the job of the court committee. Then a Chief Justice court committee's job no. What you say Jumana solely or take a sad decision no. A sad decision and a 10 practice directive no and our directions no. It is not the job of the Chief Justice. The job of the court committee. And when you read the Constitution, Article 157 no, STT clearly say the Chief Justice is not supposed to do that. A court committee no also here. Then a Chief Justice here or say and also kaho and also Chief Justice way ya pamono. Now, say, in the exercise of such functions by the rule of court committee, the said committee is required to make the rules by constitutional instrument, but not by any other instrument. Into say sa emrana Chief Justice say sebio court ewo Ghana endisuni ade no ewo say ade for the court committee no mo ye no mo krampo no ewo say omudi constitutional instrument so ewo say omudi emra so and enye any other emra into Chief Justice no e de emra foforo na sebio odema sa 10 directions no but practice directions no but anka wo hwema ewo say court committee na ye omo krampo no emra da ho krogien was a omudiso edidi sa adwuma no into who say Chief Justice I decide Madam Torkonoo or the Supreme Court and o breaking law anytime any day she did not care anything that Okache Mr. Akufo-Addo president say Miami way sack her before the 7th of January. Now ukaiku enima The practice direction issued by the Chief Justice to regulate practice and procedures in certain matters in some of the courts were neither issued by the rule of the court committee nor by constitutional instrument as prescribed by the Constitution. In issuing the said directions, the Chief Justice usurped a function constitutionally reserved to the rules of court committee. It is technically or basically the Chief Justice abused her office. The Chief Justice went against the law. Article 157. That alone, no, also Chief Justice Yapamono. Chief Justice has committed a lot of crimes. And the good thing about the petition is that the petitioner pointed to the crimes she has committed. And that is the most interesting thing about this petition. The petitioner was detailed. The petitioner directed the president to facts. And the petitioner told the president, if you even need people to be subpoenaed in front of the committee to back what I am saying now, they are all alive. You have the right to subpoena them. Put everything on camera for people to see that the Chief Justice has committed a crime and she does not deserve to be the Chief Justice of Ghana. So when you read the petitioner's petition, you could see, say, he was very clear, he was very detailed, he was very direct. He made the president understand and say, this is not out of hatred, this is out of patriotism, out of correcting the judicial malpractices the Chief Justice is involved in. Into Omar Chief Justice, President Tiase say, when your time Chief Justice Nebuso. Now, when you get to point 49. I say it is important to add that the Chief Justice issued a direction at a ceremony to which several persons were invited and state resources expended to launch them. In so doing, the Chief Justice willfully caused financial loss to the state, as the said direction have no force of law. That the disregard of the Constitution's clearly laid out process for issuing practice directions fits into the pattern of the Chief Justice's utter contempt for due process, rule of law, and the Constitution that she is enjoined to protect, preserve, and defend. Now, another point I would say, Yampam Chief Justice na ebine making of administrative guidelines unconstitutionally. Now, you read the no here. Who read the petition now? Udu point 51 or say by Article 159 of the Constitution, the Chief Justice is empowered to make regulations for the efficient performance of the functions of the judicial services and judicial council. The constitutional provision, however, says that such regulations must be made by the Chief Justice, A, acting in accordance with the advice of the judicial council, and with the approval of the president, and by constitutional instrument. Now, further, by Article 157, the Rules of Court Committee is empowered to make rules and regulations for regulating the practices and procedures of all courts in Ghana by constitutional instrument. In May 2024, when the Chief Justice launched her practice directions, they were launched with administrative guidance. These directions were made contrary to the constitutional provisions which regulate the making of such guidelines. Those practices, directives that were related to the practice and procedures of the courts were not only to be made by constitutional instrument, but only by the Rule of Courts Committee. The failure to use a constitutional instrument shows a disdain for collaborative rulemaking and preference for running a one-person show. So too is the usurpation of the functions of the Rules of Court Committee. The Constitution and our history clearly frowns upon a judiciary that depends on the solitary decision of one person. Inti petitioner no, I'm a president at TSC. Even the court committee no, so no, the Rule of Court Committee no, sa group no, answer me take that decision say Ghana court nyina ebia say ye person take a decision with Ghana. Say Ghana court bia no also almost sitting at 9 a.m. and at the end of the case bia also case bia end 2 p.m. The Chief Justice does not have the right to just go to a function and give that direction. No. The Chief Justice has to consult the President. The Chief Justice has to consult the Parliament. The Chief Justice has to make sure say and yet on no may take that sole decision. There is something we call the court the court committee. The court committee in Ukrampono, they also have to work within some laws. They need constitutional instrument to guide them to make those decisions. It's for the Chief Justice to solely make that decision and stand in public without consulting and making sure due process is followed, and just standing in public to say, I am giving this directive. The Chief Justice has flouted the law. It goes against Article 157. The Chief Justice knows the law, and the Chief Justice has deliberately broken the law. And that it means that the Chief Justice does not have to continue as the Chief Justice of Ghana. It was a precedent in the Pamono. It is looking like our Chief Justice breaks the law every 24 hours. From all that I've read, it's pointing to a Chief Justice who does not have respect for the rule of law. That is what I'm seeing. The Chief Justice does not have a respect for the rule of law because the person who appointed her does not have respect for the rule of law. The President Akufo-Addo, Omumrano. That is why Chief Justice Madam Torkonoo, per what the petitioner is saying and the evidence he's given, she is also following suit. She is not respecting the rule of law. And Intina Oka said, we have to make sure, sir, Mr. President, from what has been stated here, it was not just mere say. It was not just allegations. These are facts. Letters, meetings, dates. It was this sad way, Mr. President, also Pamo Madam Torkonoo. Now, Mamenko eye of be grounds for removal of the Chief Justice, Article 146. Petitioner said, Mr. President, in Jinaso way, and a me Jinaso catcher or say Chief Justice the boom so yam pamono, or say grounds for removal of the Chief Justice. Now, before we continue with the grounds of removal of the Chief Justice, we will take a short break. After that, na ya twaso ayedeng I can kind sa diakosi.
We've always sung the first stanza of our national anthem, which asks for God's blessing on our homeland Ghana. And it enjoins us to resist oppressors' rule. Many have not taken the time to observe the second stanza of our national anthem, and the lyrics bear reflection. It says, "Hail to thy name, O Ghana. To thee we make our solemn vow, steadfast to build together a nation strong in unity, with our gifts of mind and strength of arm, whether night or day, in mist or storm, in every need, whatever the call may be, to serve thee, Ghana, now and forevermore." This stanza calls for a nation strong in unity and enjoins us with our gift of mind and strength of arm to serve our motherland, Ghana, now and forevermore.
It's exactly 6:03 p.m. U.S. East Coast time. It's definitely 11:03 p.m. in Ghana. You're still watching With All Due Respect extended version. My name is Kevin Akobedu-Taylor. We are breaking down the petition. We are reading through the petition. We want Ghanaians to understand. The Chief Justice and that is what we are doing here. Page by page. Na ya mo ate ase de ekoso. Adekudintia I was Chief Justice Madam Torkonoo. I was Nana Addo Akufo-Addo epamono. Team, are we good? Really? Team. Semo. Let me see something here. We will We will deal with that. Mr. P. And interesting grounds for removal of the Chief Justice, Article 146. Now let's go to what the petitioner has written. The Constitution, or say Article 146(1) of the 1992 Constitution provides that a justice of the Superior Court or a chairman of a regional tribunal shall not be removed from office except for, or say, Article 146(1) echere ewo Constitution say Chief Justice eni say yapam no echere bibi say esi na nyoma na echere esi no ene na petitioner no e ka kire Akufo-Addo or say 1. Stated misbehavior or incompetence or on grounds of inability to perform the functions of his office arising from affirmity of body or mind. Now, Momiankai 62. 62. As already stated, Your petitioner's instant petition is grounded on the first two, which are stated misbehavior and incompetence. The two words are not defined by the Constitution. In discerning their meanings, however, recourse will be had to their literal, ordinary, and grammatical meanings. The reason for the recourse to the literal meaning of the words used in the Constitution is that the court have repeatedly held that regard be paid first to the literal rule of the words used in a statute, unless recourse to such meaning lead to absurdity. Now, the petitioner or say, nyoma ojina so a okasa na nado dan Kwaku Azar e wose opam Madam Torkonoo no sebio sa words na o use no obi beka say oh sa words a o use ye no constitution enim inti adenti na words a any constitution mu no yenjina so na yemfa pam Madam Torkonoo o say sebio enkyere so bi nkan kyerɛ sɛ o ma me control ansa na wo so odi ma me atam obi betuma ka kyerɛ so ma me control ni nyina it still goes down say we did ma me atam. Now or see, even though we use the exact words in the Constitution, no, this word, no, literally, no, you cannot just take it and say, because he did not basically go into the Constitution to pick exact words to say, Mr. President, Article 64, these words and these words are the ones I am basing my reasons on for you to sack the woman. No, does not mean, say, he does not have a case in making sure that this woman has been fired. He is saying, say, even though, no, in some na ojina so eka these are the grounds I am from Madam Torkonoo no and in some particular words no unu air constitution does not mean say it does not reflect or it does not represent the Constitution and the parts of the Constitution he has quoted to support the words. Et say o kind Bible udru baby a friend Proverbs. So o kind Proverbs are say okay Proverbs ni keke say mebusam anase Proverbs na you need to understand it in a certain way to understand what Proverbs the wom and no na petition ka Mr. Akufo-Addo say those grounds na me gina so aka say pam Madam Torkonoo no even though words like misbehavior and incompetence might not be found in the Constitution, no, it does not mean say when you basically sit down to look at her duties and the kind of inconsistencies and misbehavior incompetence she has exhibited during her time or during her execution of her duties, no, it does not take away say the woman has committed a crime. Inti the word itself as misbehavior or incompetence, no, it does not mean say because it's not the Constitution, no, Madam Torkonoo did not commit a crime. And no na oma nanado dan Kwaku Azar say. Sa words now we use to say stated misbehavior and answer incompetence no mema Nigerian say any constitution immunity Madam Torkonoo embo krono no he's basically making the president understand. Now or see or person or share the meaning of stated misbehavior. Now or see the definition of misbehavior has evolved over time, but it typically includes into Mr. President to say sebio obika sa wona ni control ma the same person asemo ka to say odidi ma amiatem enti we use it in different language but it all goes down to o ma me baby or say the word misbehavior, abuse of office. The word misbehavior, it can also mean abuse of office. It's using administrative powers in a manner which brings the administration of justice into disrepute. Incompetence, demonstrating a lack of ability or capacity to perform judicial duties in accordance with the standards required and or expected of the office. 3, unreasonableness, or say behaving in a manner that undermines public confidence in the judiciary, such as making decisions that are irrational, arbitrary, or engaging in inappropriate relationships. 4, corruption, engaging in bribery or other forms of corruption. Moral turpitude. Moral turpitude is engaging in a conduct that is morally unacceptable, such as fraud or dishonesty. Now, Oma President Atia say, even though he did not use the exact words in the Constitution or the part of the Constitution he quoted, the words he used, they have evolved. they also have the same meanings as what the Constitution has been stating. Nobody should hide behind grammatical errors or using words just to say because he did not use this specific word, it at the end of the day we cannot punish her by sacking her, and that he's making people understand words they evolve. You can say words evolve here. As time goes on, they start to form different meanings. They start to magnet. As they move, they start to attract and they start to change. Their meaning starts to change. And so you cannot be static or be rigid and say because when you see some specific words in the Constitution, Madam Torkonoo has not committed or flouted the laws of the Constitution or the land. It is very, very important. And into the way you butra or you in some any brofo or usually any words Mr. President say, it all means the same thing. The woman at the end of the day has not conducted herself well. She has misbehaved, and also she's incompetent to fill that office. Now, oko explanation of grounds of the petition. Oche misbehavior explanation, brazen constitutional violation. And oko down page 16. Page 16, disrepute. So what the petitioner did, and they say, the crimes the woman has committed, and he said, Obibe General Kacho said, because me, the petitioner, I did not use some kind of words or some kind of grammar in the Constitution. It does not clearly state to say the woman has committed a crime. And in petitioner, every single statement you make, he backed it with the Constitution, and where it clearly shows to say the woman, Madam Torkonoo, has committed a crime. And or make a statement to be no appoint here to the Constitution. No, the catcher says statement way when you link it to the behavior of the woman at this instance, it clearly goes against the Constitution. Inti usha petitioner. That's what I'm saying. Say Papa no Choko petition, he took his time to detail it, because when you want to let the world know, say the Chief Justice of the Republic of Ghana is not doing the right thing, you cannot just write a piece of paper and say sack her. You need to state, you need to be factual, you need to point to what crime she has committed and what crime she has committed against the state. And the petitioner from page 1, he has been able to link every behavior of this woman, which is contrary to what the Constitution states, to let us know, say, the woman has committed a crime. So it is not about grammar. It is not about you using exact words in the Constitution. It is about you pointing out the flaws and the abuse of office by using the Constitution and parts of the Constitution to back your statement. And clearly you can see, say, the petitioner, Mr. Asare, he backed every the allegation he made with facts to prove to the president to say they are not just mere allegations. These are allegations based on facts, and the facts can be pointed out through letters and also through the Constitution, what it says. Now, sir, Uridia Kodru the part where he wants to conclude that the petitioner, in his conclusion, Mr. President, this is what he said. The Chief Justice's actions discussed herein not only breach constitutional provisions, but also constitute stated misbehavior and confirm acts of incompetence. These actions undermine judicial independence and impartiality, represent an abuse of power, and create a conflict of interest. Such actions meet the threshold of stated misbehavior and incompetence as outlined in Article 1461, and therefore constitutes grounds for removal. Also, Mr. President, in some evidence I made any the part of the Constitution me quote their support me grounds why the Chief Justice should be sacked. You need to understand it clearly shows that the Chief Justice has misconducted herself, she has misbehaved herself, and she has shown gross incompetence in administering her job. So the petitioner is telling the president, when you even take your time to look at the Article 1461, it clearly states, say, he has grounds to tell the president and Ghanaians as a whole, say, the Chief Justice basically has flouted the law, she has gone against the Constitution, and it is on the grounds to say she has to be removed. Wache nyoma a chere say Chief Justice no e wo se pam no and wan chere ne keke otusie e no chere oye dey o chere otu dey otu bayira no wa chere sie otu bayira no wa chere sie otu bayira o baby no chere sie inti from what he has stated no catch Mr. President say in his conclusion no the match nyina chere say Chief Justice no we bu mra so or incompetent or say misbehaving ho, and it calls for her sack as the Chief Justice of Ghana. Now, call a page point 113. I say the Chief Justice's role is to interpret and uphold the law, not to influence the selection process of other justices of the Supreme Court or to interfere in the operations of duly constituted panels. I say Chief Justice Nejuma say obechche Ghana mrem. Nejuma no I was say or making sure say wa church Ghana mrem na Ghana mrano wa bon ho ban. Se Chief Justice ni na adwene say ordinance e be keka judges edwuma omo ye. So e na adwene say omma eye judges any judicial services no omunya adwene krogin emfa manage eye Ghana se be judiciary na say Chief Justice no or abusing the office and answer or day or court against the Constitution of the Republic of Ghana. Or could anyone not say? Or could anyone say? I'm trying to find where. Yes, her involvement in the appointment process could unduly influence the president's decision, undermining the objectivity of the nomination process. Or see the Chief Justice here, no. It can influence the decision of the president because Chief Justice Charles Takoma president. No, guys, Mr. President, me na me the head of the judiciary. Me na me Chief Justice. Me was shortlisted people. Me was protocol list. Me pesa wodi omoba Chief Supreme Court. A bit may influence the decision of the president. Bia na incompetence na Chief Justice. The Emma president as protocol list no 5 judges no. For all you know, Bia some of them are criminals. Bia, the Chief Justice is planning on conniving with some of them on personal basis or personal reasons to dupe the people of Ghana or to abuse their office. Into see, for the Chief Justice to even just suggest those things to the president, clearly can confuse the president or can influence the decision of the president, meaning the Chief Justice, who is supposed to be the protector of the law and interpreter of the law, has now become the influencer of the law, has become the suppressor of the law. And into the original side, and like I said, we don't need such people or such persons to be the head of Ghana's judiciary. How could anyone say? Here her overreach is contemptuous of the power of the Judicial Council, which she chairs. Her involvement in the appointment process could unduly influence the president's decision, undermining the objectivity of the nomination process. Her attempt to make side deals with the president puts her in a position where the president can make reciprocal demands. Or say, per the Chief Justice or throw letter. 2 letters behind the scenes without the Judicial Council knowing and conniving with the president and telling the president to do her a favor by bringing in a list she thinks is better for her. No, also the dangerous woman they say a day will come the president will also ask the Chief Justice for a favor, and that will at the end of the day undermine the justice system in this country. It means say. So President, yes, I favor with my Chief Justice. A day will come where the president's daughter will be starting trial. The president will pick a phone and call the Chief Justice and say, let it go. Abraham said the president's daughter has committed a crime through an ambulance deal of about $32 million. The Chief Justice will make sure the judge who sits on the panel or sits on the case will tell Ghanaians and say, Jan Kuruma is not guilty. Into see, these are the reasons why it is very dangerous for the Chief Justice to be suggesting to the president and having secret meetings with the president, and then their own personal vendetta or personal reasons, to be imposed on the judiciary or on the court. Into say very dangerous. when it becomes a barter trade between the president and the chief justice, then it means to say we don't have a judicial system, we don't have a justice system, and these are the reasons why Oka said the chief justice must be sacked. Now, Oko Enima or say she is therefore fatally compromised. The Constitution and the established protocols dictate the process for judicial nomination, and any deviation from these procedure is unlawful. Similarly, her reconstitution of panels impairs parties' right to a fair trial and could unduly influence the panel's decision, undermining the impartiality of the adjudication process. It strikes at the core of Article 1573, which is intended to prevent any interruptions in the judicial process and ensure continuity and accountability until a final decision is made. Her reconstitution of panels is an abuse of power in violation of the constitutional benchmark for the exercise of discretion power. The Chief Justice has no administrative role once a panel is formed and cannot interfere with the judicial functions of a panel by changing members on the panel. Public confidence in the judicial system relies on the perception of fairness and impartiality. The Chief Justice's actions described would further erode this confidence, suggesting favoritism or partiality and introducing needless frictions within the judiciary. Judicial ethics requires judges to avoid actions compromising their independence or judiciary's independence. Proposing nominees could be seen as engaging in political activities, generally discouraged, if not bad for judges. Now, the all can say, Chief Justice, take a decision to interfere. Judge on better cases, so making sure say a seminar air questiono or bet me judge, not the judge for Frabesho, or bet my catcher be say, would ya kwashaha, would ya or chinaman what now we so, would ya by force ranchain, or see, Sir Juma Dian and your Chief Justice Juma. Into the moment that Chief Justice Bernard you say obey Sadiano, then it means say pay yo and answer your court no and a judiciary no. Be a friend prepare yo and answer justice no. It will never be realized. If we say Chief Justice cost yes Sadiana, then some judges will be ruling in favor of the Chief Justice and maybe accomplices of the Chief Justice. Some of the judgments will be in favor of some people who are not supposed to get a favorable judgment. He is saying say the conduct and actions of the Chief Justice continuously reconstituting and entering panels and contradicting and forcing judges on and off their cases, which isn't her job. No? The Chief Justice is overstepping her boundaries. The Chief Justice is abusing her power. And most importantly, that confidence and belief Ghanaians a judicial system. No? The Chief Justice, through her actions, no, by influencing and infiltrating, and at the end of the day, putting her powers and imposing herself on the judges sitting on cases and reconstituting panels. No? What is going to happen? What is going to happen? And they say, na Ghana for our judicial system. No, sa GDN yira so a sebio Ghana for ne ho be kire. Now oba asewa na or say judicial ethics requires judges to avoid actions compromising their independence or the judiciary's independence. Proposing nominees could be seen as engaging in political activities, generally discouraged, if not bad for judges. Professor Jando warned us of the dangers of an unrestrained Chief Justice when he opined that, and I quote, "If we're so unfortunate as to get for our Chief Justice a cynical, mischievous, and obstinate individual who always had the ear of the president, at least a sizable section of the judiciary could be subject to mayhem with not too remote consequences of bedlam." End of quote. The mayhem is already upon the judiciary, and the bedlam will follow unless swift actions are taken to remove the Chief Justice from office on the grounds sprayed and in accordance to Article 146 of the Constitution, that's the 1992 Constitution. And the petitioner says, "I therefore petition the President to initiate proceedings to remove the Chief Justice from office to uphold the Constitution, maintain the integrity of the judiciary, and restore public confidence in our judicial system. Please do not hesitate to contact me for any further information or clarification. Respectfully submitted, Professor Stephen Kwaku Asare, P.O. Box 12889, Accra North. Telephone 02635299907. email kwakuasare@gmail.com. So that is the petition. Petition na and yedi akome Akufo-Addo a ye gina so aka se Madam Torkonoo e wo se ye pam no ene na medwudwo machiro all the evidence emu letters secret meetings, secret letters are Chief Justice Torkonoo Akufo-Addo against the constitution. Any basis are the petitioner actually say grounds are actually say the misbehavior and also the incompetence, and the Chief Justice at the end of the day infiltrating our judicial system, imposing her will on our judicial system, and also favoring the president and his government on some political cases. The facts are there. He has pointed to the part of the constitution that clearly states that the Chief Justice of the Republic of Ghana has to be sacked. And it is very important that we all understand to say, he still has days. He needs to take action. He needs to constitute a committee. He needs to make sure the process starts. Mema obi mbedane na non kaka se Nanado Dankwa Akufo-Addo nembra so adhere oyamba so Mahama ba na wabe committee. John Mahama is not president. Akufo-Addo needs to take action. So Nanado Dankwa Akufo-Addo take action. Na John Mahama beto petition we no take action. Nobody should say a witch hunt. This is something Akufo-Addo needs to do. So believe say the Chief Justice is not guilty. She has not abused her office. She is not an autocratic Chief Justice who is incompetent. Nanado Dankwa Akufo-Addo should form a committee and make sure this is heard on camera for us to know, say, the petitioner is making a case or is not. And if the Chief Justice is clean and squeak, and the Chief Justice has not committed a crime, we all will come back and say she should go back to the Supreme Court and occupy that office. If Nanado Dankwa Akufo-Addo fails to take action on this petition, then it means we the people will have to force the next government to take decision on this petition. And it's very important you and I understand this ABC. I'll be back to continue tonight's show. You're still watching With All Due Respect Extended Version.